Good afternoon. It is 12 o'clock noon on Friday, the 13th of September, 2024. And this presentation is part of the Ask a Lawyer series, a collaboration between the Sacramento County Public, Public Law Library and Housing and Economic Rights Advocates, which is a nonprofit law firm. And I see we have some more people joining us. So I am going to wait about 2 minutes before I get started with this topic today, calling all animal lovers, pets, service, and emotional support animals in housing. So I see people are joining. I know it's the lunch hour, so I'm just going to wait about 2 minutes, as I said. Thank you. Well, let's go ahead and get started. I see we've had a few more people join us this afternoon. Good afternoon. My name is Amina Merritt. I'm a staff attorney at Housing and Economic Rights Advocates, which is a nonprofit law firm in California, which offers low and moderate income people legal services throughout the state of California. You can go on our website and see more about our services. But this presentation today is a collaboration between the Sacramento County Public Law Library and Housing and Economic Rights Advocates. This is a Ask a Lawyer series, which we've been presenting since June. The last webinar will be next month in October, and this is the next to the last one, calling all animal lovers, trying to talk about the three distinct legal categories between pets, service animals, and emotional support animals. So if you have questions that come up during the presentation, please type your questions into the Q&A box as you listen, and we will try to answer them at the end of the presentation. Also, please note that this presentation is for informational purposes only, and it does not create an attorney-client relationship between the participants and either Sacramento County Public Law Library or Housing and Economic Rights Advocates. And more information and resources will be provided for you on this topic at the end of the presentation. But for now, here are some resources for the Sacramento County Public Law Library. They have many online materials that you can access on their website, and also the great reference librarians at Sacramento County Law Library are available on this email address or by calling this number. And the library is actually located at 609 9th Street in Sacramento, and many, or actually every county in the state of California has a county law library, or you can find help at your public library in your city. Also, HERA has many resources on economic help and housing issues on our website, www.heraca.org. And you can call, email, or call this number to get a consultation with an attorney. We also have a YouTube channel where we have published some webinars. There's one on Habitability 101, what tenants should look for in a lease or rental agreement, what tenants should do about mold, and other topics, including a 5-series domestic violence survivor series. Also, please take the brief survey linked in the chat box at the end of the presentation, which helps with our reporting. Thank you. So let's jump right in. This topic, it's important to make the three legal distinguishing categories of animals so that you understand what rights you might have as a tenant or a resident of any dwelling. And we'll get to what that means in a second. But it's important to recognize that pets, service and assistance animals, and emotional support animals are three distinct legal categories and carry with them different protections and rights. So, with respect to pets, generally, tenants do not have protections against private landlords restricting common household pets in apartments. And there are some exceptions to that, which we'll talk about. Service and assistance animals are the same thing, and they cannot be excluded from housing, but we'll talk about what special requirements apply to those type of animals. And most people are most familiar with emotional support animals, ESAs. These animals have the most legal protections and the fewest restrictions. And there are also some crossovers with these categories, and we'll talk about those in a few minutes. So when I use the term tenants, I'm referring to anyone who is a resident in any kind of a dwelling. And let's first, though, talk about um, common household pets. What does that mean? What are common household pets? Well, some people are surprised to learn that there are about 20 or 30 different types of commonly understood household pet: dogs, cats, hamsters, rabbits, guinea pigs, birds, fish, mice, turtles. But those are ones we think of, but people also have chinchillas, ferrets, reptiles, horses, and lizards. And the category of common household pets is pretty long, and it includes about 20 to 30 recognized animals. And it also excludes dangerous animals that are poisonous, probably not certain deadly poisonous snakes, spiders, and other crawly things. I like to give the example of my friend from law school who had a boa constrictor as a pet, and she ended up getting rid of it because it kept escaping her apartment when she was the U.S. attorney in New Mexico. And her neighbor, who was a police officer, advised her she probably shouldn't have that. That was back in the 80s, before landlords were really putting restrictions on the types of pets that you could have. And so just be sure that you know what the restrictions are, because private landlords do have the legal right to restrict pets in housing, and it will be set forth in your lease or rental agreement. And many of the leases and rental agreements that are being used in California in 2024 do contain clauses about animals, pets, and many of the leases in 2024 do contain what's called a pet addendum, which will talk about breed and weight restrictions on types of animals and what types of animals are actually barred from where you are living. So let's actually look at one. Here's a good example of a animal lease clause in a California lease that is current in 2024. Paragraph 14 relates to animals. And this one says that no animals are permitted without prior written consent of the owner, and that the consent can be revoked at any time with or without cause by giving 10 days notice. And so, except to the extent that written permission is given at this location, no animals may be brought upon the leased premises, whether the animals belong to the residents or to any other person. That might be a legally challengeable clause, because suppose you as a resident have someone who is blind visiting you with an assistance animal. I'm not sure that you have to get prior permission for that person to come visit you with their seeing eye dog. And that is something that would probably become an argument if your landlord tried to prevent it. This clause, though, also says that the presence of any animals as to which written permission has not been given and is not in force, um, even if just visiting, is deemed a material breach of the lease agreement and cause for terminating the tenancy. That would be probably arguable. Again, I say you might be able to challenge that clause for a visitor with a seeing eye dog or assistance animal. And they do say, though, this policy does not apply to accommodation or service animals. But it also says that a disabled individual who requires an animal in order to be able to use and enjoy the leased premises or the residential community should contact the owner before bringing the animal into the community and request accommodation. Now, I have a little quarrel with that as well, because suppose you are a disabled person coming to the community to seek housing at that community. I would argue that you do not have to get prior approval to show up at that leasing office with your seeing eye dog to ask to look at or to inspect an apartment or otherwise look into becoming a resident there. So there's some issues with that, but it's a pretty tight paragraph 14 regarding animals. And then what also happens in addition to the animal clause is there might be this addendum, the restricted animal breed list. And this says that this is a policy that is made a part of the rental agreement. And so this is to be considered part of the lease and is a rule that must be followed. And so here you see that there are some restricted dog breeds at this location. And it excludes some types of breeds that are considered a wolf or a wolf hybrid. I've given this presentation and had some scientists on the line, some veterinarians who argue about whether Mastiff pit bulls and Rottweilers are actually dangerous dog breeds. They argue that they're not. And there is some literature out there that says that Rottweilers and pit bulls should not be around babies and small children. And there are those in the industry of animal breeding who disagree with that as well. But this policy prevents you from having those, even Akitas and Malamutes and St. Bernards, known for rescuing people. Those are excluded by this animal breed list. And you'll see also poisonous animals cannot be brought on the premises, including tarantulas and piranhas, which are man-eating fish. And then exotic animals that they consider to be ferrets, skunks, raccoons, squirrels, rabbits, and even birds, parakeets and parrots and cockatiels are not allowed. Parrots and cockatiels do tend to make a lot of noise. But this is what this location wants to restrict in terms of animals. I do say that any tenant who has one of those might have to request some kind of permission to have such an animal. And then there's also this animal addendum, and this is all three of these provisions are from the same lease for the same premises. And so this animal addendum talks about whether a deposit is required, and it says that no animals are permitted without consent of the owner. So this animal addendum is simply reiterating paragraph 14 of the lease. And it's also talking about all the community restrictions related to, and keep in mind, this is all related to pets at this location. And so it talks about having liability insurance, being responsible for injuries caused by your dog or pet. And that's just common knowledge. You would have to have insurance if you have a dog that bites, and you would need to think about your liability for that particular type of animal. And so that pretty much covers what I think there's another page of this. Yes, this is the rest of the pet policy, the pet addendum. And you can see that this was provided by FPI Management, one of the largest management companies in California. I also want to point out that when I talk about pets and landlords and tenants in the previous screens, that also applies to shelters. And this is an important point, and this is a new addition. If anyone attended this presentation last year, we did not talk about shelters, but in the last year, we've had lots of questions about whether shelters are treated the same way as apartments and whether the law related to pets, service, and emotional support animals apply to shelters. And the Short answer is yes, because shelters are defined as dwellings under the law, and they are subject to the same animal laws as landlords. And here are two sources for that interpretation. California Code of Regulations, Title II, Section 12,005, Subdivision O, subsection 2, enacted in 2020. This is the 2024 version of that section. Any building or structure or portion that is occupied, designed, arranged, or intended to be occupied as a home, residence, or sleeping place. And then the Fair Housing Act of the federal statutes, 42 USC section 3602B, defines a dwelling as any building, same sort of definition, any structure designed, which is occupied, designed, or intended for occupancy as a residence by one or more families. And the definition of family under the Act includes a single individual. So a person entering a shelter with the intent to sleep there or to stay for any period of time is considered a tenant in housing. And so the same laws apply. So shelters also have the right to restrict pets by their policy, their rules, or other agreements that they might enter into, the same as the landlord can restrict by pet policy, rule, or regulation in their lease agreement. Shelters may have program rules and regulations, or if they're getting their funding from a particular program or federal program, there may be federal regulations and rules that apply that they will cite in their rules and regulations. And with respect to shelters, I have done some encouragement of shelters to actually develop a pet policy that can be applied across the board, and also to make it clear what the pet policy is to all those who enter the shelter, and make sure you distinguish between pets, service animals, and emotional support animals. And so let's get away from pets and talk about service and assistance animals. So basically, service and assistance animals are not considered common household pets. So the prior discussion we had about common household pets does not even apply. For the purpose of applying the law for service and assistance animals, we can look to the Americans with Disabilities Act. And as a practical matter, housing providers can only ask a person, is the animal a service animal? And does it assist with housing? These are two important questions at the shelters when people come to sign into a shelter and they claim that they have a service or assistance animal, or that it's an emotional support that animal that helps with their disability. The shelter can only say, is that a service animal? And does it assist you with your housing? Can't ask what the condition is, can't ask, how does what certification does the animal have? No, if the animal performs a service for the disabled person, they're entitled to have that service animal with them. And so assistance animals, just to be more specific, can be service or assistive animals that help someone with their disability. It helps them to use and enjoy their housing. So there are these signal dogs which will bark, or if you are hearing or sight impaired, you could have a signal dog that lets you know when someone is knocking on your door, or when something else is happening that you need to be alerted to. Service animals are specially trained to work or perform tasks for a disabled person, such as a seeing eye dog helps a person to navigate spaces. And there are guide dogs that help hearing impaired people as well. Other assistance animals perform tasks, assist, and provide emotional support for a disabled tenant. And this I point out because this could make the animal fit into two separate protected categories. It assists the hearing impaired person, but it also provides emotional support for the person's disability and possible for their emotional state if they also have a dual diagnosis, for example. So assistance and service animals can be both, and they can also cross over into the category of being an emotional support animal. So a person with a disability walking into housing should be allowed to have their service or assistive animal if it's needed to enjoy their housing. And there are a number of cases we'll talk about a little later that deal with whether there is the necessity. There's a bunch of case law about the necessity for an assistance animal. So here are some of the laws, some of the other laws that apply to assistance animals and service animals. This is federal law, the Fair Housing Act I cited earlier, 42 USC section 3601, et cetera. That act prevents discrimination against tenants in housing, and it provides reasonable accommodation for persons with disabilities. And that includes service and assistance animals. The Americans with Disabilities Act, which is found at 42 USC 12101 at SEC, provides the definition of service and assistance animals, and it states where those animals are allowed in public places. It states how those animals are to be controlled, and it also outlines some invalid policies governing animals. If you look at the Americans with Disabilities Act and the references that are cited in that act, you can find the guidances that have been produced by the federal government for enforcement of the ADA. And there are many guidebooks online that you can find to help enforce the provisions of the Americans with Disabilities Act. And this next slide helps to show better. This is applying the law as it applies to federal housing programs, 12 USC section 1701 R through L. These provisions apply to most federal housing programs, including USDA rural housing. And these code provisions cover conventional public housing. They give the regulations for when pets are used in public housing, and they do set up the procedure for reasonable accommodation under the Americans with Disabilities Act in public housing, prohibits landlords in public housing and housing programs from requiring tenants to pay deposits or rents or insurance for their assistance and service animals. And it also prevents discrimination against applicants who have common household pets. And it states it gives guidance on how landlords and other housing providers can give reasonable accommodation. It really gives you some step-by-step guidance on how to reasonably accommodate tenants who are in public housing. Another federal provision that applies to pets is Section 504 of the Rehabilitation Act of Section 1973. Most people know this as the requirement for having IEPs in education for children with disabilities. But this section of this portion of the Section 504 Rehabilitation Act allows service animals in housing that receives funding from HUD. So if a housing provider gets any kind of HUD subsidy or is in any kind of federal housing program, they are required to allow service animals in that housing. And it prevents them from discriminating against those who need emotional support animals or assistance or service animals. Again, you can't charge a deposit, you can't charge pet rent, and you can't require pet insurance for service and assistance animals. The The only condition is that the pet must not be a danger to the health and safety of others in the housing or in that program. And you can be validly charged if the pet causes any kind of damage. And just a note about public housing authorities, because if people are living in public housing or any kind of Section 8 or subsidized housing program, they may have a public housing authority that helps to implement their housing. And the HUD regulations grant public housing authorities broad discretion in establishing pet policies, and those policies must be reasonable and conform to the local law in that city. And I say this one little bullet point: removing a pet's vocal cords is not reasonable, because actually there was a case where a landlord tried to have a disabled person get their pet's dog's vocal cords removed. That water is under the bridge. You can't make the pet get surgery to change the pet's condition or nature in order to be able to access the housing. That is not reasonable. Also, state law protects pets in housing. The California FEHA, Fair Employment and Housing Act, found at Government Code sections 12.955, etc., applies to all landlords and housing providers, and as I told you earlier, to shelters, which are considered dwellings. So it prevents housing discrimination, and again, under state law, provides for reasonable accommodation. The same as the federal law prevents pet deposits, rents, or insurance for service and assistance animals. And once again, same caution: the animal cannot be a danger to the health and safety of the others who live there, and that you can be charged for any damages. The other California state law, Unruh Civil Rights Act, found at California Civil Code Section 51, prevents housing discrimination and requires reasonable accommodation for persons with disabilities. And so this is designed to provide full and equal access to all housing accommodations, mailboxes, laundry rooms, common areas. And this has come up because some landlords tried to say that people with service animals, assistance animals, or emotional support animals cannot bring those animals out into common areas or into the laundry room or to the mailbox. And that is not what the law envisions. People with disabilities who have service and assistance animals have to have full and equal access to all aspects of the housing, the same as all the other tenants who live there under this provision. Next, we come to the Disabled Persons Act. That's the provision of the Unruh Civil Rights Act. It's section 54 point. Actually, this is a separate provision from the Unruh Civil Rights Act. This is the California Disabled Persons Act, section 54.1, and that has the same type of provisions as the Unruh Civil Rights Act. I didn't go to that screen, sorry guys. There it is. This also prevents housing discrimination, and it says that every individual with a disability has the right to a guide dog, signal dog, or service dog, which is specially trained. And the thing about these guide dogs, these signal dogs, service dogs, these animals have gone through extensive training to be able to help disabled people. And most of them do come with a certificate of their training. These dogs are highly skilled, and most of the time the people who have them do have a certificate that shows that these animals are specially trained, but they are not required to show that to any housing provider in order to say, I have a disability and this animal helps me with it. And you cannot charge, again, the pet deposits, rents, or insurance. You see that all of these code sections, including, again, California Food and Agricultural Code section, governs the regulation and licensing of dogs and has the exact same language as the California Disabled Persons Act. That's why I put these lined up like this. So you can see that all of these state law provisions have the same provisions designed to prevent housing discrimination against people with disabilities. It's been extensive, it's been vast. The discrimination against people who have assistive or service animals that they absolutely need to live their lives. And all of the laws that have been cited thus far are designed to help those people be able to access and navigate their housing. So these are important state provisions. So just to summarize once again, assistance and service animals are the same thing. They are not considered pets, and residents can never be prevented from having them. And these animals are specially trained to assist the disabled person to use and enjoy housing. I've already gone through these provisions of the law and told you charges can only be made when damages are caused, animal can't be a danger. And also if the shelters are or housing provider get HUD money, they are subject to the federal regulations as well on the provision of pets, service, or emotional support animals. So that's the discussion on service and assistance animals. And here is some case law related to the pet policies that we were talking about. Woodside Village versus Hertzmark. This is a big Connecticut decision, which said that the eviction of a disabled tenant was allowed because they failed to comply with the pet policy, even though the landlord had made reasonable efforts to accommodate the tenant, and he was still unable to control the dog. This Northern District, California decision, Fair Housing of the Dakotas versus Goldmark. This is still good law. The court denied the realtor's motion for summary judgment on its pet policy because the court wanted to address the issues of disparate impact and failure to reasonably accommodate a specially trained assistance animal under the FEHA, under Fair Housing Act. Actually, that was the Federal Housing Act. Green versus Housing Authority is good law in the Ninth Circuit. Mother and her deaf son were granted summary judgment because they needed an assistance animal as an accommodation. And there was no impact on the Housing Authority, and the Housing Authority still tried to prevent them from having the assistance animal. And finally, Auburn Wood gets cited a lot all over the country. 2004 California case where the Housing Commission of California decided to accommodate a resident's request for a small dog for depression, and the trial court overturned that under the state FEHA, and then the Court of Appeals reinstated that commission decision. So again, providers must provide now we're going in, sorry, I didn't transition. We're going into now emotional support animals, and we'll just have a quick discussion of this before we begin to entertain some Q&A. Housing providers must provide a procedure for residents to request reasonable accommodation for their emotional support animals. And you'll remember that paragraph 14 did allude to written permission being required to have an animal in the premises. So if you have an emotional support animal, it would be best to ask the landlord under that clause 14 to accommodate the emotional support animal. And the housing provider has to give you permission unless the animal imposes an undue burden or fundamentally alters the services at that location. And I showed you the Code of Federal Regulations earlier that define shelters as dwelling. These regulations say that housing providers have to accommodate people with emotional support animals. And there have been situations where the landlord doesn't even consider the written request, or doesn't even offer a process for the tenant to be able to request to have an emotional support animal. And that violates both federal and state housing laws as cited earlier. I want to make a point that normally residents who have emotional support animals who have a known mental health disorder or condition usually already have a letter from a doctor or some other mental health provider that specifies their need for their emotional support animal. But let me just say, they don't have to, because SB 774 was enacted in California in 2022, and it's now codified in the Health and Safety Code section 12231A3A through B, and it creates an exception for a homeless person who hasn't been able to establish a relationship with a healthcare provider, and so they don't have a letter that says this is an emotional support animal. The homeless housing provider, the homeless person's housing provider, has to give them 30 days to get that letter. They can't exclude the emotional support animal for 30 days. And at that point, they can say, oh, did you get the letter that supports your need for an emotional support animal? And, it could be argued that they should extend that time as a reasonable accommodation, because homeless people have such difficulty navigating services and may not even have a healthcare provider. And so the ability to get a letter from someone, a mental health provider or a doctor, may be difficult. And that needs to be considered. And that is the purpose for this health and safety code section being enacted, so that time can be given. And housing providers should consider what is reasonable under the circumstances, to give that person the opportunity to keep their emotional support animal with them. So here are some other resources. The Civil Rights Division of the U.S. Department of Justice has a guidance on service animals, which can be found here under the ADA section. HUD, Housing and Urban Development, has the Public Housing Occupancy Guidebook, which discusses pet ownership in public housing. There's also one that is a guidance for assessing any request for reasonable accommodation for an animal. And then there's also this Fair Housing and Equal Opportunity Office notice that was put out in 2021 to provide further guidance for housing authorities to assess a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. And finally, Disability Rights California, a great organization in our state that advocates for people with disabilities. And this website contains a number of fact sheets on the rights to assistance animals in housing, and other fact sheets on the rights of disabled people to access housing, and how those fact sheets can help landlords and tenants alike to understand what the law regarding animals. So thank you for your attention. We're going to open it up now to see if we have any questions. Let me look in the chat box here. I see a question here. Does an emotional support animal require documentation for the landlord? Can the landlord require these documents? So yeah, for emotional support animals, the landlord is allowed to ask you for a letter or document from the doctor. We just covered that. I'll go back to that slide for you. So they have to have a procedure in place for you to ask for permission to have the emotional support animal. If there is already, let me make it clear, sometimes there is no pet policy. If there is no pet policy, then there needs to be some guidance for the tenants or the residents who live in that housing. And so if there's no policy that the landlord has stated, all the tenant can do is go by the law. And the law is what is stated in this presentation today. So the Code of Federal Regulations would require the landlord to accommodate the emotional support animal unless there is some problem with having that animal in the apartment. And if there's no pet policy, it's going to be more difficult for the landlord to restrict anyone from having an emotional support animal. But for the resident, the safe thing for a tenant or resident to have available is a letter from your mental health service provider or doctor that says, this tenant suffers from a mental health condition. It doesn't have to identify the condition, and it doesn't have to say that the doctor is treating you for something. It just has to be a letter that's, and actually, there are online websites all over the internet where people can get a letter saying they can pay for a letter saying that this pet is an emotional support animal and provides emotional support for this tenant to be able to use and enjoy their housing. Once it's in that letter can be used for all purposes, and it can be submitted to your landlord to give you the right to keep the emotional support animal with you. And it documents your need for the emotional support animal. And if a person is a homeless person, they get some time to try to get such a letter if they don't already have one for their emotional support animal. But emotional support animals don't require any kind of special training, so they don't automatically come with some service animal certification or record that they've had some kind of special training, and they don't have to have any kind of special training. It's the tenant who says, this animal, this bird, this turtle provides emotional support to me. And it's the doctor's letter who says that person has a condition that needs an emotional support animal. And the doctor doesn't say it has to be the turtle. It's whatever that person gets emotional support from is the animal. And unless it's poisonous, dangerous, or, a piranha or a man-eating something, it should be allowed unless it's dangerous to others or can cause some kind of undue damage. So I hope that clarified a little more. Looks like we have some other questions. Can mobile park home, can mobile home park owners allow a vicious dog on the property? The answer to that question is, as with every legal question, it depends. But what I would say, I would look to is, first of all, where is the mobile home park located? Depending on the county or the city, there may be some local ordinances. I know I had a case in Los Angeles where Los Angeles, I didn't even know, had a local ordinance on the number of cats a person can have in the city of Los Angeles. And that's a different number of cats than if you live out near the beach in, West LA. West LA's cat policy allowed 5 cats where LA only allowed 3. And so there may be a local ordinance in the city where you live that specifies what a vicious dog is. I also did some dog bite litigation in Los Angeles many years ago, and a vicious dog is defined, was during the 80s, defined under the local ordinance as a dog that had bit someone more than twice. And you get 2 dog bites and that's it. And the third time it's a vicious dog, and animal control can put the dog down. So when you use the term vicious dog, that actually does have a legal description, and it may be found under the local ordinance. And if there is a vicious dog, the mobile home park may have a pet policy that says no dangerous animals. And if that dog fits in that category, the owner should prohibit that dog from being on the premises. You may need the assistance of the local animal control to get a designation that this dog is vicious. And if the dog has bit someone before, there may be a public record of that. that the dog is vicious and possibly should not be living in that environment. But it would take some additional facts to be able to definitively answer that question. I hope that was helpful. Next question is, if you think your neighbor has a vicious dog, what can you do? Must there be, I kind of answered, must there be a dog bite to take action? And like I said, it depends on what city you live in. Like I said, LA had a 2 dog bite policy, and then it's considered vicious and dangerous, and animal control can actually put it down. If you think there is a vicious dog living with your neighbor, you could call animal control in your city and tell them what you have observed and file, I think they take anonymous online complaints at in Los Angeles. I'm not sure where you are in the state, but many of the city governments in our counties in California have animal control. I know LA County has animal control, and there may be a local animal control in Sacramento. But throughout the state, the animal control department has different, it's either state, uh, county, or local. And if you can access that agency, they are the people responsible for addressing the problem of the vicious dog. And also the landlord should too, because it does affect what is considered your right to quiet enjoyment of your premises. And if the dog is interfering with that, you may not be enjoying your apartment the same as the person who actually has the vicious dogs. So that's something to take up with your landlord. You may want to formally complain to the landlord if your lease does have a pet policy and ask the landlord to enforce it. Many leases also come with a nuisance clause, and every lease in California has an implied warranty of habitability and quiet enjoyment. And so a vicious dog may affect those, your rights as a tenant to have quiet enjoyment of your premises. And if that's the case, you may have to ask your landlord to enforce the provisions of your lease. And it's difficult when a landlord does not want to enforce their own policies, and then the other residents have to try to make the landlord enforce the policies. It's possible to do that through small claims court, but then you're digging into your own pocket to enforce a right that you have under your contract. And so not sure if you want to have to do that. In any event, that is a tactic on how to act. You could also call, code enforcement in your city if you feel that the dog is violating some kind of a health and safety code or building permit code or something. Code enforcement is able to assist with that. Let me see if we have another question. I think I answered all that was there. Yes, I don't see any other questions. So we're at about, what, 10 minutes still? If anyone has, yeah, we still have about 10 minutes left. I guess I flew through that a bit quickly, but while I have a few more minutes, I just want to give another plug to housing and economic rights advocates. We have a number of resources on our website where you can learn about debt and credit issues, student loan issues. We do solar panel fraud. We have teams that are working on the student loan problem, which many people have right now. But if you go on www.haraca.org, you can see on our website, you can link to our webinars, you can link to our YouTube channel, you can link to the various teams that we have: debt and credit, solar panels, student loans, foreclosure prevention, estate planning, all of those for low to moderate income people, free legal help, and especially housing. I'm on the housing team, and we do talk to tenants all over the state regarding their housing matters. So if you have a housing landlord-tenant issue, you can call this number 510-271-8443 extension 300 and ask for a consultation regarding your specific issue, or you can shoot an email to us at inquiries@heraca.org and someone will contact you to set you up. There is a raised hand, so let's see what the question is. Sandra Font has a question. Can you type it in the chat or type it in the Q&A box? In the meantime, let's see. Let me see if I can unmute you. So also, lastly, I don't see Ms. Font question. Ms. Font?
Yes.
You had a question?
Yes, I do. I have a service dog who's been on the property for 5 years. She's a yellow lab, professionally trained.
I'm sorry to interrupt you, Ms. Font, but I cannot answer a specific legal question.
Okay, let me ask.
You can call Hera and you can get.
I can ask a more general question then.
Okay.
Can public housing landlords require demonstrations of the off-leash tasks of a service dog?
No. That's absolutely no. And as I said when I talked about public housing authorities are not only subject to all of the laws that I just cited, but there are also the federal regulations. And no, a landlord can't do that. Your housing navigator or your housing authority case manager should be the person advising that landlord of what the proper legal requirements are and what the federal regulations provide. And you can use the law that is stated in this PowerPoint that supports the fact that that landlord cannot do that. No. There's no demonstration of service animal tasks. None of that is supposed to go on. As long as the animal has been designated a service or assistive animal, they've already been trained and someone else has already certified that that dog or cat or whatever type of animal it is a service animal. And so nobody else gets to second guess that by requesting some demonstration or dog and pony show. No, they don't get to do that.
Okay, then thank you.
Okay. And if you want more specific, contact us at this number or shoot an email and say you want to talk to an attorney you can get a free hour consultation to talk about the specifics and tell us where you are and maybe something needs to be done to further educate that public housing authority and or that landlord, because honestly, a lot of that is what the tenant team has to do at HERA is educate landlords. It's surprising how little they are aware of certain law and are required daily to implement it and don't properly do so. And I find that to be true, especially with people with disabilities, the Americans with Disabilities Act, and the mechanism for providing reasonable accommodation. And that's why there are so many guidebooks available. The guidebook that I cited here, I'm going to go to it down here at the HUD. That's what this landlord needs to look at. Sandra Font's landlord needs to look at the HUD handbook that is found here. This HUD handbook, the guidance for assessing a request for reasonable accommodation. That only applies if it's an emotional support animal. But they should look at this public housing occupancy guidebook, because that will give them all the federal regulations they need to know. That HUD landlord, that public housing landlord needs to know what the regulations, the federal regs on assistance animals and emotional support animals. And there's plenty of guidance from HUD on these issues. So no landlord should be questioning it. And our Department of Justice in California has a number of guidebooks, the California DOJ, but this is the federal. And these guidebooks are spot on. They cite the law that applies, and they tell you who the public housing regulations apply to. I see a typo there. There's a typo. So if there are no other questions, hopefully, Ms. Font, those guidebooks can help as well. And, if you want to get some heat to bear on your public housing authority or your public housing landlord, contact HERA. We have some specialty in dealing with public housing authorities, and many of our housing advocate partners in the state do as well. And public housing authorities are at the top of our list for problematic uh, enforcement of tenants' rights. So with that, I guess we will end this webinar. And before I do, please do fill out the evaluation in the chat box. We need those evaluations to further grant monies to help tenants further throughout the state. So if you would be so kind as to make your comments, I'd appreciate it. And thank you all for attending. It's really important to know that people are interested in these topics that we are presenting. Hope you have a good day, good rest of the day, and a great weekend. Bye.